For well over 300 years, Kahnawake has consistently fought for the return of lost lands and revenue from the Seigneury of Sault St. Louis. On July 1, 1867, when the British North America Act was passed, it created the country of Canada. This act also assigned legislative jurisdiction over Indians and lands reserved for Indians to the Canadian Parliament. On April 12, 1876, the Indian Act was introduced, the product of two separate older laws that sought to assimilate and enfranchise Aboriginals across Canada. The law allowed for the federal government to impose reserve status on unceded Seigneury of Sault St. Louis lands and took control of the management of reserve land. Under the Canadian administration, several issues arose with respect to the collection of seigneurial rents on the seigneury. Over the 19th and 20th centuries, changes to the seigneurial management allowed landholders to buy out their holdings for very little compensation without Kahnawake's consent. This resulted in yet another loss for the Kanyankahaga. In 1890, this prompted Member of Parliament Minister Doyon to address the dispossession of the Iroquois seigneurial lands and revenues before the House of Commons. Sadly, nothing came of his appeal to the governing body. In 1935, Quebec's Seigneurial Rent Abolition Act was applied to seigneurial lands, resulting in further loss of potential revenue. During the same period, the province of Quebec was successfully able to assert an underlying interest in the seigneury lands and rents before the courts. In the 1950s, approximately 1,262 acres, around one-tenth of reserve land, was expropriated along the northern boundary of the seigneury to build the St. Lawrence Seaway. An injunction against the expropriations was denied based in part on the view that the Iroquois of Caughnawaga only had a right of use and no right to property in the disputed lands. Since then, the Mohawk Council of Kahnawake has actively pursued compensation for the loss of Seigneury of Sault St. Louis land and revenues. In the 1970s, Chief Ron Kirby requested information about the collection and management of seigneurial rents from Canada. Then Minister Jean Chrétien replied that the rents had not been collected since the agency office burned in the mid-1940s, and that it would be very costly to reconstruct the records. In the 1980s, the Mohawk Council of Kahnawake became involved in several research projects to investigate and pursue Kahnawake's claim to the seigneurial lands and revenues. In 1994, the MCK entered a joint Seigneury of Sault St. Louis research project with Indian Affairs to develop a special claim for the historic land dispute. In a positive turn of events in 2003, Canada extended an offer to negotiate the Seigneury of Sault St. Louis land grievance as a specific claim. The MCK accepted their offer to develop a joint mandate to negotiate. A negotiation protocol was formally signed in 2005 to begin the negotiation process and renewed in 2010. Canada made some changes in 2007 to the specific claims process and categorized the Seigneury of Sault St. Louis as a specific claim valued at over $150 million. From 2010 to 2015, the Seigneury of Sault St. Louis teams found that they could not make progress in negotiations under the federal specific claims policy. Today, talks on the Seigneury of Sault St. Louis have restarted with the Crown Indigenous Relations Minister appointing a special ministerial representative to develop a new approach to negotiate the Seigneury of Sault St. Louis land grievance. For more background on the Seigneury of Sault St. Louis land grievance, visit KahnawakeClaims.com.